we have to discuss is the right of abortions in India. Now this is important. वैसे तो ये static चीज है. Now why we are discussing in present context? Because of two reasons. First, there was an amendment 2 years ago, and also following year there was a very you can say backward looking judgment by the United States Supreme Court. United States Supreme Court बोलती है कि women के पास abortion का right नहीं है. There is a very famous case, Roe versus Wade. Right? So this particular case in United States granted this right of female to have the medical termination of pregnancy. Abortion, what you also call is the medical termination of pregnancy. तो United States की Supreme Court पिछले साल ये बोलती है कि women do not have the right to get aborted, to get their fetus aborted. Now consider a situation when they are calling themselves a Western civilized nation and they are coming out with this kind of backward looking judgment. We also have constitutionally recognized, legally also we have recognized this right of abortions. There is a Medical Termination of Pregnancy Act, उसको क्या बोलते हैं, MTP Act, and this act is of 1971. But the journey was even not smooth in India. There were various obstructions like Roe versus Wade in India also. So there are two sections of Indian Penal Code. One is section 312 and section 313. These two sections of the Indian Penal Code effectively bans unconditional abortions in India. Right, ये है आपके नोट्स में मेंशन. So section 312 क्या कहता है कि anyone voluntarily causing a woman to miscarry, या तो उसको कन्विंस करके या उसको डिसीव करके या फिर उसको अबेट करके कैसे भी, if they are inducing a woman to cause the miscarriage of their fetus, they are liable to be punished with an imprisonment of 3 years unless he was acting in a good faith to save the life of the woman. This is section 312. Section 313 also punishes a person who causes the miscarriage of a woman. Now see, according to the law of the land in India, law is not only what is mentioned in the law books. It has various sources. It is derived from the customs, it is derived from the culture, it is derived from the various pre-existing law को हमने codify करना बाद में शुरू किया 19th century में. But before that, Hindu law and Islamic law both were existing, however in the uncodified format. So as per the Hindu law, you will find there is a Transfer of Property Act also, so it is codified. But अगर आप Hindu succession की बात करते हो, so the moment a child comes into the womb of their mother, they acquires a right in their ancestral property. And that right cannot be alienated from them. ये दो तीन there are 2-3 schools of Hindu law, मिताक्षर दयाभाग. तो इन मिताक्षर this concept is there, दयाभाग is there in the Bengal area में ये concept नहीं चलता है. So what happens that a moment child is there into the womb, a property can be transferred to that. अभी वो जिंदा नहीं है तो भी. So this means we have to protect the life of that particular child. So this is why there was a provision which was inserted into our IPC considering this thing, that already we can transfer the property to the child. The child is having the right in the inheritance. So we are not considering the life which is only outside on the surface of the earth. The life which is about to come also was considered a life as per the existing legal notions in India, however not codified. So this was further protected by these two sections of IPC. Now if going by the virtue of this section, it is completely impossible to have the abortions. But there are certain occasions when these abortions are required. What if due to advancement of medical science, we were able to analyze that there are certain fetus which are malformed? Then what happens then? कि बच्चा आएगा बाहर तो वो disability के साथ आएगा, and he will have to suffer the pain through lifetime. So why not it's better that they are not brought to life? Or if there is a threat to the woman herself, the mother herself, कि pregnancy के समय कई बार ऐसे हो जाता है, there is a threat to the life of the woman itself. So in that situation, it is important to protect the present life or to protect the future life. Now society also, ये तो आपकी क्या होगी, medical conditions हो गई. But it's not only about the medical conditions, it's also about the social situation, it's also about the choice. When to have a child, when not to have a child must be the say of the woman who is going to have the child. However, in rural India specifically, you want these choices are highly curtailed. So society भी grow कर रही थी और medical science भी grow कर रहा था. It was pertinent that we should allow abortions as a country, as a society. तो एक कमेटी बिठाई गई, कांति लाल शाह कमेटी, and that committee recommended for creation of an act. That act came to be known as MTP, Medical Termination of Pregnancy Act 1971. Now this committee, this act कुछ नहीं कर रहा. The basic purpose is to provide for exceptions from these two sections. Otherwise तो कोई भी termination of pregnancy करो, 2 सेक्शन है, जेल जाओ 7 साल के लिए. 313 सेक्शन में 7 साल की जेल है, तो बंदा जेल चला जाएगा. डॉक्टर अबॉर्शन करने जाएगा, फिर जेल चला जाएगा. He will be doing an offense. So that exception is provided by Medical Termination of a Pregnancy Act. 1971 provision provided certain things older, and these provisions has been now changed as per 2021 amendment. आई थिंक नोट्स में आपको 10 है तो 10 ही है. हाँ, 10 साल तक की सजा है, ठीक है, मैक्सिमम. दैट इज नॉट द एग्जैक्ट, इट कैन बी अप टू. जो भी सेंटेंसेस लिखे जाते हैं ना, वो अप टू लिखे जाते हैं, इट्स नॉट द एग्जैक्ट, ठीक है. तो इट कैन बी, इट डिपेंड्स अपॉन द दिस थिंग जुडिशियल माइंड व्हाइल दे आर गिविंग द सेंटेंस. तो सजा को कैलकुलेट करने के बहुत सारे पैरामीटर्स है. प्रीवियसली वो काम करके आया हो, बार बार वही कर रहा हो, तो उसकी सजा इंक्रीज होती रहेगी, है ना, ठीक है. नाउ सो अंडर द न्यू एक्ट, अर्लियर देयर वाज अ प्रोविजन. Let's have this thing. So before amendment of 2021, and this is 2021 amendment. So basic provision was up to 12 weeks the abortions were allowed. 12 weeks from the period when the fetal gestation starts. So 12 weeks from the pregnancy starts. वहाँ से लेके from the date pregnancy is starting, from then till 12 weeks it was allowed to have the abortions quite normally, and it was only required to have the opinion of one medical practitioner. One medical practitioner. अगर 12 हफ्ते के बाद करनी है, but there is again a limit. From 12 to 20 weeks it was allowed, but with the advice of 2 medical practitioners. 2 डॉक्टर की एडवाइस लेके आनी पड़ेगी. Beyond 20 weeks there were no abortions which were allowed in the original 1971 Act. Now various challenges started to surface. Firstly, this act before 2021 amendment was not inclusive in nature. 1971 में abortions and pregnancy was only possible in our society in case of valid marriage. Unless and until there is a marriage, we could not expect that there will be pregnancy. Biologically, medically it was possible, but society के नज़र में pregnancy तभी हो सकती थी जब आपकी शादी हो. Because there were no concept of live-in relationship या फिर ऐसा कुछ. But society has also progressed. Now there are couples who are living in live-in relationship. There are chances of going into the relationship and pregnancy might occur, which may be wanted also, which may be unwanted also. Both are possible and both are legally permissible also. ऐसा कोई ये crime नहीं है, offense नहीं है, ठीक है. Now what happens then? अगर मान लीजिए कि ये person, there are 2 persons who choose themselves to be the parents despite being under a marriage, without being under a marriage, and a moment later or after 4 or 5 months the woman is into the pregnancy, their relationship breaks down. So what happens? Now see, the pregnancy was an outcome of a common choice. Now the relationship status is changing. So why women should be let going with that pregnancy? Why should be why she should be forced to continue with the pregnancy? Despite that this was a common choice, now it is not a common choice because the other person has moved away. हो सकता है, क्योंकि अब क्या होगा कि now until unless there were a couple, so उसके father का भी नाम था, उसके mother का भी नाम था, and raising a single child is quite a tough task in our society. So there may be several social and there may be several other problems the women is supposed to face. These kinds of connotations were not present in the previous act. अब क्या किया है, वहां पे क्या था कि women, in the previous act the word written was women and consent of her husband. So husband basically means if you are under a valid marriage, but now this word husband has been changed to partner. Partner may include husband also, and partner may include other persons living as a husband who are not a husband also. So it is a kind of broadening the scope of the act which will cover the other relationships beyond marriage also, which are legally valid also in India. ठीक है. So पहले क्या किया हमने, word को change किया from husband to partner, right? Now what happens, these provisions with regard to the limitation on the time has also been changed. Why there was a need to change for that कि 20 weeks से बढ़ा के आप 24 weeks कर दो? Why? Because there are certain fetal abnormalities which can be visible only after 20 weeks. उस सिचुएशन में what happens that there is a victim of the sexual assault and later on she discovers that she has become the pregnant. तो पहले तो 3-4 महीने उसको छुपाना है, सोसाइटी की प्रेशर्स है, लीगल कानून का डर है. Now why should be a woman forced to firstly see itself a victim of any rape or any forced sexual intercourses? तो वैसे कई सारे situations थे under which it was found that beyond 20 weeks also we would need that pregnancy termination could be allowed. तो हमने क्या कर दिया है, पहले कि जो प्रोविजन था up to 12 weeks इसको हमने क्या कर दिया है 20 weeks, and till 20 weeks it can be terminated directly with the consent of one medical practitioner. There is no requirement. पहले 20 हफ्ते तक करना होता था तो 2 मेडिकल प्रैक्टिशनर को चाहिए होती थी, अब एक ही मेडिकल प्रैक्टिशनर से हो जाएगा. From 20 to 24 weeks the pregnancy can further be terminated. 24 weeks मतलब 6 महीने, out of 9 months it's almost 6 months till which it is now allowed. क्वेश्चन ये भी हो सकता है कि फिर 9 months तक क्यों नहीं अलाउ कर देते हैं. प्रेगनेंसी इन द लेटर स्टेज इफ इट टर्मिनेटेड इट ब्रिंग्स एन एडिशनल थ्रेट टू द लाइफ ऑफ मदर हरसेल्फ. तो वहां भी मेडिकल साइंस उतना आगे नहीं हुआ है कि अब 9वें महीने में भी आप बच्चे को मार दो, माँ बच्ची रह जाए. ठीक है, so there may be certain complication. This is why it is not legally allowed beyond 24 weeks. After 24 weeks it is allowed only in the exceptional cases when there is a medico-legal board which is constituted with 4 persons and that 4 persons examines the case particular. 24 week तक normally कर सकते हो आप. For 24 weeks the legal provisions are clear. But even if the pregnancy has to be terminated beyond 24 weeks, it can be possible, but only if a medical board is constituted with a team of 4 members and that boards examine the case, the threat associated to the life of mother, and then if it gives approval, it may be continued beyond 24 weeks. But till 24 weeks, it's prescribed under the law how it can be done. So till 20 weeks, it can be done with the simple advice of one medical practitioner. मतलब इसके लिए कुछ नहीं चाहिए, आप एक हॉस्पिटल में जाते हो जो ड्यूली क्वालिफाइड है अबॉर्शंस करने के लिए, दे आर रजिस्टर्ड, दे आर कॉम्प्लाइंट विद द लीगल नॉर्म्स, वहां पे आप डॉक्टर के सिग्नेचर के साथ द पर्सन कैन गेट देयर fetus aborted. From 20 weeks to 24 weeks there are certain cases only in which abortions are allowed. For example, if there is a survivor of rape victim, उनके जो fetus है they can be terminated from 20 weeks beyond also, but till 24 weeks. Generally beyond 24 weeks rape victims के भी fetus को termination की allowance नहीं है. Then there may be another situation when relationship status of the women has changed, that I was talking about. One person has moved out of the relationship, right? There may be certain mental illness. It is found that the woman who has conceived, who is about to become the mother itself, she is not mentally sane that she could bring up a new life. तो ऐसे में वो खुद के now she is not able to upkeep herself. How it is supposed to upkeep their children also? So in that situation, if the mother is found to be not mentally sane, it can be terminated also. So mental illness of the women is one thing. There may be another situation when it is highlighted by the medical science that the fetus is malformed, and if they are born into life, they would be disabled for life. So there is no purpose of bringing that to the life. That pregnancy can even be. Now it is not that कि ऐसे बच्चों को आप terminate ही कर दो. It is a choice again of the mother. अगर कोई mother she is more emotional, she is more connected, if she wants to raise a child, it is their choice. So this is about the choice which is being given by the MTP Act. If the women want to terminate the pregnancy, they can, right? जब तक ये एक्ट नहीं था तो उसको चॉइस ही नहीं थी. There was section 312 and 313, तो वो तो उसको प्रोहिबिट करता था. Now this is the women are enabled with the choice. If they want to terminate the pregnancy, they can. If they do not want to, they can continue with it, right? So in case of fetal malformation, so these are certain situations during which the abortions is possible as per the 2021 Amendment Act. These are certain changes which has been brought. Now this was important. The context I have already told. The changes in the features I have already told. इससे ज़्यादा I think direct questions तो नहीं आएंगे मेंस में. अब इससे ज़्यादा क्या ही पूछ देगा. सिंपली पूछेगा कि डू द वुमेन हैव द राइट ऑफ रिप्रोडक्टिव चॉइसेस इन इंडिया, व्हाट आर द लीगल प्रोविजंस फॉर रिगार्ड टू इट। क्वेश्चन आते हैं तो अगर इस तरह के जो स्पेशल लॉज होते हैं ना उनसे बहुत डायरेक्ट क्वेश्चन आते हैं। घुमाने वाले क्वेश्चंस आपके कॉन्स्टिट्यूशन के प्रोविजन से आएंगे, स्पेशली द कॉन्सेप्ट्स ऑफ द कॉन्स्टिट्यूशन लाइक ड्यू प्रोसेस, रूल ऑफ लॉ, इक्वालिटी, लिबर्टी, सेक्युलरिज्म, इन सब से उस तरह के क्वेश्चन आएंगे विच रिक्वायर्स द मल्टी डायमेंशनल अप्रोच। अगर कोई एक्ट आता है फॉर एग्जांपल रिप्रेजेंटेशन ऑफ पीपल एक्ट, आप देखोगे एवरी टाइम इफ दे आर आस्किंग द क्वेश्चंस आर वेरी डायरेक्ट इन नेचर, व्हाट आर द ग्राउंड्स ऑफ डिस्क्वालिफिकेशन एंड व्हाट आर द सॉल्यूशंस अवेलेबल, तो इट्स क्वाइट डायरेक्ट क्वेश्चन। सो इफ एनी क्वेश्चन इज कमिंग फ्रॉम स्पेसिफिक एक्ट लाइक दिस, इवन द क्वेश्चन मे कम फ्रॉम द न्यू डेटा प्रोटेक्शन एक्ट, राइट, डिजिटल डेटा प्रोटेक्शन एक्ट, उससे अगर क्वेश्चन आता है देखोगे वो क्वेश्चन अपने आप में kind of the direct question है। At max they can find that critically analyze the new data protection act, तो उसमें आपको थोड़े पॉजिटिव्स भी चाहिए, थोड़े डिमेरिट्स भी उसके पॉइंट चाहिए। राइट टू प्राइवेसी, उसके आपको सारे डिमेंशंस चाहिए, राइट। सो फॉर दिस आई थिंक इट इज सफिशिएंट इन्फॉर्मेशन ऑन दिस टॉपिक, यू विल बी एबल टू गेस। अगर बाद में आपको कोई इस पे आर्टिकल मिलता है एंड यू गेट एनी न्यू इन्फॉर्मेशन, सो दैट इज योर रिस्पॉन्सिबिलिटी, यू विल नोट डाउन इन द नोट्स, राइट। So this is another facet of Article 21, that is medical termination of pregnancy.